Now, today we are going to talk about classification of contract on the basis of formation. So, how the contracts have come into existence. On that basis, contracts are classified into three types: expressed contract, implied contract, and quasi contract. So, one by one, we will discuss what does it mean by what. First type is on the basis of formation, expressed contract. Now, what does it mean by expressed contract? So, when the contract has come into existence in an expressed way. So, contract is expressed either by use of words or words, those are spoken words or written words. That contract is called as express contract. A says to Y that I will sell my car to you. I want to sell my car to you for 1 lakh rupees. B says that I'm ready to purchase your car for 1 lakh rupees. So this is an expressed contract in by way of orally expressed contract. So A writes a letter to B telling that I offer to sell my car to you for 1 lakh rupees. B writes in return that I am ready to purchase your car for 1 lakh rupees. So this is a contract which is expressed in writing. So a contract, when it has taken place in expressed manner by use of words. When words are used to create a contract, either spoken words or written words, that contract is expressed contract. Now, second type of contract, and that is implied contract. So implied contract means where the offer and acceptance are made, but words are not used. But offer as well as acceptance is implied through the conduct of the parties, and these are implied from the circumstances. Such agreement is called as implied agreement. Such contract is called as implied contract. So where offer is not given, there is no offer, no acceptance, but offer and acceptance are implied from the conduct of the parties or implied from the circumstances. That contract or that agreement is called as implied agreement. What is an example of that? So in our day-to-day life, we enter into implied contract. So example, if a person enters a bus, immediately after entering the bus, do you enter into contract or agreement with the conductor? Do you go to conductor and say that I'm ready to pay you the bus fare and you drop me to this destination? Then conductor accepts your offer. He says that yes, you pay that much money, I will drop you. No need to enter into contract or agreement with conductor. So when a person has entered a bus, that means he is ready. There is implied promise that he is ready to pay the bus fare, and it is implied from by that conductor or driver will drop you to your destination. So it is implied from the conduct of the parties. No use of words is made. That type of contracts are called as implied contracts. Again, you go to a restaurant. Do you immediately after entering the restaurant, do you go to a manager of the restaurant and say that I want to consume these many items here, these many food items here, and what will be the cost of that? I'm ready to pay that. He says that yes, I accept your offer. No. When you have entered the restaurant, you ask for the menu card, you consume some eatables. That means you are ready to pay for that. So these type of contracts are implied contracts where offer and acceptance. For offer and acceptance, no words are used. So it is implied from the conduct of the parties or it is implied from the circumstances. Next type of contract is quasi contract. Now, what does it mean by quasi contract? So the meaning of this term quasi contract means semi-contract. So this also term on which always 2 marks question is asked, define quasi contract. So literally the meaning of this term is semi-contract. Now, quasi contract is such a contract which is created by law. Usually other contracts are created by the parties to the contract, but here this contract is not created by parties to the contract, but this has created by the law. That means this quasi contract, we cannot call this contract strictly as a contract. Why? Because we have seen that there is one essential element of a valid contract. First is agreement. Agreement is created by way of an offer and acceptance of that offer. In case of quasi contract, there is no offer, no acceptance. Again, second essential element, we have seen that there should be an intention to create legal relationship. Again here, in case of quasi contract, there is no intention of the parties to enter into contract. So this quasi contract, it is an exception to the rule that there has to be an intention to create legal relationship to create a contract. Therefore, this contract, class quasi contract, is called as a semi contract. It is not full contract. In the strict sense, we cannot call it as a contract because there is no offer, no acceptance, no intention to create, no intention to enter into contract between the parties to the contract. So this concept of quasi contract is based on the principle that a person shall not be allowed to enrich himself at the expense of another. So the basic concept of this term quasi contract is no one should enrich himself or herself at the cost of another person. What is an example of quasi contract? So it is a relationship between finder of lost goods and the true owner. So whenever someone loses something or someone is lost, something is lost, and the person who gets that thing, say for example, you all know me and you know my cell phone and my cell phone is lost. You are one of the finders of the cell phone. Now, is there any contract between you and me? So I am the owner of the goods, I am the owner of the phone and you are the finder of the phone. You know phone belongs to me. So whether there is any contract between you and me, I had given an offer to you that if in case in future I may lose this phone will be lost, you return it to me, you accept the offer. There is nothing. In spite of that, law imposes certain duties on the finder of lost goods. What are the duties? These are the duties of the finder of lost goods to find out the true owner and return those goods to the true owner. So there is no offer, no acceptance, no intention to create legal relationship, even though there is obligation or duty on both the parties. Finder of the lost goods has to, it is the duty of the finder of the goods to return those articles to the true owner. After getting that article, true owner, it is the duty of the true owner to give whatever he has agreed to, whatever the finder of the goods has spent money to find out the true owner, whatever he has spent, he has to give it to him. So this is the example of that. Again, there is an example, that is example, say for example, there is one book person and there is one bookseller. Bookseller has to send some books to a person. Books are sent to the wrong addressee. The person who has not paid for that, he has not ordered for that, and the goods are sent to him. The person, say for example, you have received some books, you have not paid for those goods, and by mistake you have received those goods. Now, whether you have any duties? Yes. So it is your duty either to return those goods to the bookseller or to pay for that. So these are the examples of quasi contract. So quasi contract is legal obligation, legal duty, and this duty is imposed on a party, and the parties to a contract have to perform that duty. There is no intention to create legal relationship. Parties have not decided to enter into contract, but there is a duty which law imposes, which is to be performed by the parties. So quasi contract, it means some things you have to keep it in mind about quasi contract. It is also known as, it is the meaning of this is semi contract. Quasi contract is created by parties? No, not by parties. It is created by law. So it is strictly, it is not contract because there is no intention amongst the parties to enter into contract. No one should enrich himself at the expense of another. If you keep those books with you, so it will be gain to you, but it will be a loss to the bookseller or the person who has ordered the books and paid for those books. So therefore, these are the examples of quasi contract. Thank you.